Hello intellectuals, welcome to our channel. Today we are going to discuss about the relationship between ILO and India in the ratification of the conventions and recommendation on the labor laws. We all know that the constitution is the supreme law of our country and all the laws are based on it. Yes, the constitution has a significant impact on all the laws, especially on the labor laws, which is guarantees its citizen a socialistic pattern of society and the formation of welfare state. Indian labor laws are greatly influenced in preamble, fundamental rights, directive principles of state policy, and the judicial wisdom. The preamble to the constitution is a reflection of a core constitutional values that embody the constitution. It declares India to be a sovereign, socialist, secular, democratic republic committed to a justice, equity, liberty for the people. The main objective of an Indian constitution on the labor law is to ensure the social equality, freedom, individual dignity and social justice to the workers. The state is responsible for ensuring the political stability and welfare of the people. Now, let us discuss what are the constitutional provisions with regard to labor welfare laws are available in Indian Constitution. The protection and safeguard of the labor has been enshrined in the Indian Constitution under the chapter 3 and 4, which is also called as Fundamental Rights and DPSP. Part 3 of the Indian Constitution enumerates the fundamental rights. Article 14 is particularly important because it states that the state shall not deny to any person within the territory of India equality before the law or the equal protection of laws. Article 16, which prohibits the discrimination and also guarantees for the equal opportunity in the public employment. Article 19, which protects the right of freedom of speech and expression, right to peaceful assembly without use of arms, right to use assemble in unions or the association, the right to practice any profession and the right to engage in any occupation, trade or business. These constitutional protections, which is include the minimum standard legislations, are crucial in the area of labor law. Article 21, which enumerates that everyone has a right to life and liberty. Also, Article 23 and 24 prohibiting the human trafficking and forced labor. The Constitution's 7th schedule envisions the distribution of legislative power between the central and state legislature on the various issues. The schedule is divided into 3 lists: central list, state list and concurrent list. List 3 is called the concurrent list, which addresses the majority of the labor related issues. This covers the variety of topics like maternity benefit, employer's liability, workman's compensation, invalidity and old age pension, social security, social insurance, employment and unemployment, labor union, industrial and labor dispute, provident fund, etc. So the parliament has passed the labor laws in almost all of these areas because the majority of the labor related issues are concurrent list. However, the state have amended the Central Act to meet their local needs and have obtained the President's approval for the changes. Social economic justice is the main objective of the directive principles of state policy. Article 38, 39, 41, 42 and 43 are serve as a Magna Carta of industrial law or its foundation. The concept of social justice is outlined in the Article 38. The right to livelihood has been included in Article 21 according to the Supreme Court's interpretation of Article 39A. Article 39B and C has the impact of India's entire economic system. In accordance with Article 39D of the Constitution, Parliament has passed the Equal Remuneration Act in 1976. Article 42, which requires a state to provide the maternity leave and fair and human working conditions. Article 43, which speaks about the living wage and the comfortable working conditions. In this slide, let us discuss about the relationship between ILO Constitution and the Indian Constitution. We all know that the Indian Constitution came into force partly in 1949 and partly in 1950, which assuring all the people the basic and fundamental human rights like equality, freedom, individual dignity and social justice. All these concepts were inherent in the constitution of ILO to the Indian Constitution. The philosophy of the constitution of ILO is apparent in the Indian constitutional philosophy. In fact, Indian labor law is the practical side of the Constitution of India. The extent of impact of the ILO standard on the Indian labor legislation is very significant. For the purpose of assessing the impact, it would pertinent to be divided initially all the ILO conventions and recommendation into some categories like basic human rights, human resource and development, employment of women, employment of children and young person, general conditions of work, wage policy, wage fixing machinery, social security of workers, migrant workers, labor administration and the labor relations, workers of non-metropolitan territories, etc. India's association with ILO. India is one of the founding members of the International Labour Organization and has been playing very proactive role in the proceedings of the ILO ever since its inception. The membership of ILO ensures growth of tripartite system in the member countries. At every level in the organization, government are associated with two other social partners called workers and employers. Being a founding member of ILO, India has deep respect of international labor laws and standards. ILO follows in principle and the true spirit of the four pillars of decent work agenda of ILO, that is, fundamental principles of right at work, employment, social protection, and social dialogue. ILO conventions are international labor instruments or treaties. The ratification which creates legally binding obligations upon the states. As on July 2015, ILO has adopted 189 conventions and 204 recommendations. Out of these conventions, India has so far ratified 43 ILO conventions and 1 protocol, which includes 4 core conventions like Forced Labor Convention, Equal Remuneration Convention, Abolition of Forced Labor Convention, and Discrimination, Employment and Occupation Conventions. ILO Fundamental Convention. The 8 fundamental conventions form an integral part of United Nations human rights framework, and their ratification is an important sign of member states' commitment to the human rights. Overall, 135 member states have ratified all the 8 fundamental conventions. Unfortunately, 48 have yet to complete the ratification of all the 8 conventions. The 8 core conventions of ILO are Forced Labor Convention, Abolition of Forced Labor Convention, Equal Remuneration Convention, Discrimination Employment Occupation Convention, Minimum Age Convention, Worst Form of Child Labor Convention, Freedom of Association and Protection of Right to Organized Convention, Right to Organize and Collective Bargaining Convention. The 8 conventions have taken together are more relevant today in the face of global economic and the challenges impinging on the welfare and livelihood. Ratification of ILO conventions by India. As we discussed earlier, India has ratified 6 out of 8 core conventions of ILO. India has not yet ratified the core convention called the Freedom of Association and Protection of Right to Organize Convention 1948, number 87, and Right to Organize and Collective Bargaining Convention 1949, number 98. The main reason for non-ratification of these ILO conventions due to the certain restrictions imposed on the government servants. As communicated by the Department of Personnel and Training, that is DOPT, the ratification of these conventions would involve granting of certain rights that are prohibited under the statutory rules for the government employees, called strike to work, to openly criticize the governmental policies, to freely accept the financial contribution, to freely join foreign organization, etc. In India, we ratify the ILO convention only when the national laws are brought fully into the conformity with the provisions of the convention in question. India's approaches to ratification. The approach of India with regard to international labor standard has been always positive. The ILO instruments have provided the guidelines and useful frameworks for the evolution of legislative and administrative measures on the interest of labor. Ratification of a convention imposes legally binding obligation on the countries. Ratification procedure. Ratification on ILO convention is a voluntary process. India follows an elaborate process for the ratification. India ratifies an ILO convention only when the national laws and practices conform with the provision of the convention concerned. First, after the adoption of the ILO instrument in the International Labour Conference, the member country has to place it before the competent authority for the information. Secondly, it will examining the possibility of ratifying an ILO convention in the context of our legal framework. Thirdly, it go through the consultation with the concerned ministers and the other stakeholders. Once the concurrence is obtained on the ratification issue, a cabinet note on the convention is prepared by the Ministry of Labour and the Employment. On approval of the cabinet note, a statement is placed before the parliament and the same is communicated to the ILO for information. Once an ILO convention is ratified, India is obligated to provide the periodic report regarding the application of the convention. After ratification of ILO convention, it becomes legally binding. A ratifying country is subject to the international supervisory procedures. Implementation of convention is the final phase. The implementation of ratified ILO convention is ensured by the framing of legislations or amending the existing laws. As a result of every ratified convention in India is either backed by a supporting legal framework or embedded in the constitutional guidelines. Though India has not ratified some of the core conventions of ILO, it attaches the deep significance to ILO labor standards. It believes that the process of ratification of ILO convention should be gradual and adequate time should be given to the member state for creating a favorable condition for the ratifications. Follow up to the ILO convention. Periodical reports are submitted to ILO in respect to ratified conventions. These reports indicate how the provisions of the conventions are being implemented in the country. These reports are sent to the ILO between 1st June and 1st September of every year. Cases against India are also examined before the ILO Committee on Freedom of Association. India prepares an appropriate comments and the relevant replies to the observation and direct request made by the committee of experts on the application of convention and recommendation on the implementation of various provisions in the different conventions ratified by India. So intellectuals, to know more details about the labor law, please do subscribe the Courtroom Intellectual and hit the follow button.